is informed subrogation, and the only way to be successful is literally to know more than the other guy. And that's been our philosophy for quite some time. There's several things that combine to make auto subrogation one of the most difficult areas of subrogation, the perfect storm, if you will. There's 51 different jurisdictions with 52 bodies of law, including federal law. There's a mixture of fault and no-fault states, which mix about as well as oil and water. Subrogation is an ever-moving target. Auto subrogation and liability laws change like the weather, so we have to stay on top of that, and that's the function of these webinars. In addition, cars and trucks travel, and they travel across state lines, involve the various states, and they necessarily bring into the subrogation equation a mixture of 2 or more state laws that have to be justified, rectified, and evaluated before you can determine and act on your subrogation rights. So this is the #1 question we get from our website, which, by the way, has a feature on it where you can ask subrogation questions 24 hours a day and get an answer within 24 hours. So this is an area of litigation, auto subrogation, that's been targeted for anti-subrogation efforts more than any other because it affects more cases than any other. So this webinar is scheduled for 60 minutes. We're hoping to get it done within 60 minutes. But without any more details, I'd like to turn over to Noah, the issue of what insurance is required in the great state of New York. Noah?
Okay, thank you again, Gary, and appreciate your labeling New York as a great state, as indeed it is, along with 49 others, of course. And just the overview of coverage required in New York. Of course, New York requires both bodily injury and property damage coverage, generally 25, 50, 10. It's 25 for injury to one person, 50 to all injured parties, and 10 for property damage, with a bump up if death is involved. And there is an optional med pay, which I've asked many an adjuster exactly what med pay is, and no one really knows, but it basically covers some medical bills when your regular no-fault doesn't apply. Often involves off-road vehicles or other, specialty vehicles that don't fall into the PIP scheme. So then we go on to the big one, which is going to be the source of a lot of recovery opportunities, which is a personal injury protection. It's mandatory in New York, and it's on a no-fault system, though with a number of important exceptions to the no-fault. The basic PIP coverage covers $50,000 of both medical expenses as well as lost wages. A key term to be familiar with is the term basic economic loss, which basically is the statutory definition of what exactly has to be covered within PIP. So basic economic loss is basically synonymous with PIP, and a lot of the statutes that you will read will key the rules to the term basic economic loss. And then you have an option for additional PIP. Additional PIP really does 2 things. One is you can get out-of-state coverage, and the key here is that injuries to non-New York residents for accidents outside of New York are not covered by the basic PIP, and so out-of-state APIP would cover that. So the common example would be New York vehicle driving in New Jersey resident is in the vehicle, then New York PIP would not cover that New Jersey resident for that accident, only if the out-of-state election on APIP was applied would that happen. You also have full APIP basically means you can increase your PIP coverage by increments of $50,000, and that's what the additional PIP is. There's also optional basic economic loss, OBEL, so there you see that phrase basic economic loss again. And basically what OBEL does is it extends PIP from $50,000 to $75,000, and in that case all that $75,000 is considered regular basic economic loss. So there's an option to add $25,000 to basic economic loss. Then we have uninsured, underinsured motorist, and supplemental uninsured motorist coverage. This is your normal type of uninsured and underinsured type of coverage. One point for the SUM for the supplemental is that regular UM coverage in New York does not cover accidents that occur outside of New York, and the SUM will cover that. Otherwise, these are pretty standard for uninsured and underinsured type of coverages, and of course a lot of subrogation opportunities, but often not with deep pockets on the other end. Moving along, next slide, please. My pages are a bit out of order. Okay, so general information on subrogation. We have equitable and contractual subrogation rights are recognized by New York. General idea is let's let whoever's at fault ultimately pay the costs of the loss, and also avoid double recovery to the insured. So there are equitable rights that can be recognized, although the anti-subrogation law is going to call that into some question. And then there's also within the insurance contracts often subrogation rights. Intervention, sometimes insurers can intervene into their insured's claim against a tortfeasor to attempt to recover. New York, we'll discuss a little bit, has different appellate departments. Only one of those appellate departments really approves of intervention. The other departments feel it gets in the way. So oftentimes intervention may not be allowed unless all parties agree to it. And that will come up sometimes. Some people say, hey, I don't care. It's all going to come out of my pocket anyway, and let's get everyone together into one room. So sometimes intervention will happen even when the case law suggests some objection to it. New York. Yes.
No, I was just going to add that part of our philosophy in New Jersey, and he's right, New Jersey does frown on intervention.
New York.
For some rather, I'm sorry, New York, for some rather crazy reasons. But well, so does New Jersey, which they frown on it as well. But relying on the plaintiff's cause of action, the BI cause of action runs a couple of significant risks. The one I see most often, and I see it after the fact when my clients try to rely on their statutory lien, is that the insured's attorney forgets or refuses to honor the subrogation interest, or the insured is not able to prove the serious injury threshold and therefore cannot recover for non-economic damages, destroying the subrogation interest. So it's just important to remember that it depends on which appellate department you're in New York, although New York courts do tend to frown on subrogated carriers intervening. We do try to intervene in cases where we think it is important.
All right, thank you, Gary. New York just recently entered the ranks of more strongly anti-subrogation states through amendments to the collateral source rule and in addition to the New York general obligations law. For the moment, basically what this law says is that for personal injury claims and really for medical costs and the like, that you can only subrogate them when when there is a statutory right of recovery. Then it can be done. Otherwise, it's going to be limited. There's some exceptions which we'll go through as we continue along the webinar. And we'll also note that there's a pending amendment to the anti-subrogation law, which might have more of an effect as we move along. But the general rule is that for your economic losses for personal injury, you're not going to be able to subrogate unless there's a statutory right. We now go on to the New York court system. Yesterday, Gary had mentioned that there are certain things in New York that are obscure and arcane, and here you have it. New York's court system has built up over time and has created some interesting situations. And you see the structure here. I don't want to go through too much detail. One of the interesting points that New York's Supreme Court is the lowest court of general jurisdiction. It's not supreme. It's not the last place you go. It's often the first place you go. And I remember when I was in law school, I met a New York Supreme Court justice, and being the young whippersnapper that I was, I asked him, let me ask you something. What does New York not understand about the word supreme? He seemed less than entertained by my question, and explained how New York's Supreme Court is the lowest court of general jurisdiction. And then I said, but lowest doesn't mean supreme. However upset he might have been, he still offered me a clerkship, so it couldn't have been that bad. In any event, what do we mean lowest court of general jurisdiction? That means you can always sue someone in New York Supreme Court in any of the counties, and you will have asserted jurisdiction. So, for instance, you might have a $200 damages claim for an accident in New York. If you sued them in the Supreme Court up in Buffalo, you would have successfully asserted jurisdiction, preserved your statute of limitations, etc. It might be that the court will kick the case to another venue, maybe to one of the county courts, the civil courts, some of the lower courts that cover lower dollar amounts, but you've at least asserted jurisdiction. And then you do have lower courts that you can go into initially, for instance, New York City Civil Court for claims for accidents in the city, and basically that will also assert jurisdiction, but if you really don't belong there, you might be in trouble. So that's basically how it works, and sometimes, frankly, New York attorneys are very confused as to exactly where the suit should properly be filed. That's the unfortunate truth of it. You see also there's appellate courts, and some of the lower civil courts, you actually go to the Supreme Court for the initial appeal. As we move on, we're going to cover a little bit about the PIP recovery. And PIP recovery, you see, the first big issue is whether the vehicle you're recovering from is a covered person, which, painting with a bit of broad strokes, means, does the vehicle that's at fault have PIP? Is it part of the New York PIP system? When it's a covered person versus another covered person, you see no recovery for economic damages covered by PIP. Anything that's covered in PIP is not going to be recoverable from the tortfeasor. No recovery for non-economic damages unless there is serious injury. So you have a serious injury threshold. That's also, by the way, going to be the case for the UIM coverage, that those will only be paid out if there's a serious injury. And in turn, if you're subrogating, you'll need to prove serious injury in order to recover your UIM benefits from a tortfeasor, if that tortfeasor shows up and defends the case. APIP is recoverable. So if you recall, I mentioned the key phrase, basic economic loss. The way the statute plays out is it says if it's covered person versus a covered person, that you can't recover basic economic loss. Since additional PIP is coverage that goes over basic economic loss, the statute does not restrict recovery. And in fact, when the anti-subrogation statute was passed a few years ago, they put in a special carve-out saying we don't mean to extinguish the APIP recovery, which until then was really only a common law right of recovery. Next slide, please. Okay, as we move along, medical payments, usually in the form of PIP, APIP, or OBEL. Those are your main forms of benefits, and we went over them. MedPay subrogation, in our opinion, is probably prohibited by the operation of the anti-subrogation law. You see 5-335 prohibits subrogation and prohibits any recovery if there is a settlement. So if our insured has settled a bodily injury claim, we can only do our subrogation if we have a statutory right of subrogation. There is no statute that provides for a right of subrogation for MedPay. So once our insured has settled their claim, then our right of recovery is extinguished. And so oftentimes if we were going to assert a right of recovery, all we'd really be doing as helping get the bodily injury claim settled so that people could write us out of our recovery. In trial, there's the New York collateral source rule basically says, with certain statutory exceptions, you can't, any injuries that were covered by insurance can't be admitted in the trial on the insured's claim. So the insured goes to trial, they can't prove, well, I had all this loss that was covered by my insurance company. And that again means in that trial, the insurance company can't prove their damages. So if, for whatever reason, let's say there was no settlement, the bodily injury claim went to trial, went to verdict, then we might have a separate right of recovery for our damages, but it couldn't be proven in that trial. It would have to be proven through another litigation, and that's why we'd probably have to assert our own suit for recovery. Moving along, UIM subrogation. We won't go too far into it. Happens fairly often, but of course, usually not too deep of pockets. There is language in UIM in New York allowing for subrogation. There is provisions that require the insured to cooperate with that subrogation, not do anything to prejudice those subrogation rights, etc. So we do have an opportunity for recovery in UIM. Also, there is a mechanism if the tortfeasor's policy is offered to the insured, usually if they were going to accept that money, would have to give a release for the bodily injury claim. So there's an opportunity for the insured to front the money that was offered by the tortfeasor's carrier and say, you know, we'll give you the $25,000 that the carrier was going to give you, so this way we can go ahead and continue to assert our claim, our subrogation, and hopefully get that $25,000 back from their insurer, but also get to some of the personal assets of the tortfeasor. Moving on a little bit more about no-fault subrogation on the next slide. We have, can I get the next slide, please? Okay, thank you. Subrogation against non-covered persons for PIP or OBEL. If you remember, I said OBEL, optional basic economic loss, is just another form of PIP, so the same rules apply. So we can subrogate against a non-covered person. This is often going to be an uninsured person or someone who's come in from another state who's not part of the New York PIP scheme. A little bit more on that in a moment. New York has a very interesting statute that says if we are recovering from a non-covered person, that for the first 2 years, our right of recovery is limited to a lien on the bodily injury claim of our insured. And if our insured files suit within 2 years, that we have a lien against that suit. However, if the insured does not file suit for their bodily injury claim within 2 years, then and only then a right of recovery attaches directly to the insurer, and the insurer can file suit starting on the first day of year 3, can file a direct suit for recovery of our PIP paid against a non-covered person. Out-of-state vehicles and out-of-state accidents. So out-of-state vehicle coming into New York is going to be a non-covered person and recoverable unless the carrier that insures that vehicle writes in New York, writes any insurance business, or is affiliated with any company writing New York business. And that doesn't necessarily need to be auto. So let's say the insurer of the vehicle coming into New York writes life insurance in New York. That will be enough that they are basically deemed to have New York coverage and therefore would become a covered person. Similarly, there's an opportunity with certain benefits and detriments that an out-of-state insurer can file with the Motor Vehicle Commission, basically saying if an accident happens in New York, we will conform our policies to New York law, and we'll appoint the Commissioner of Motor Vehicles as our agent for process. And if they do so, then they also become covered persons, and all the rules of covered persons applied. Out-of-state accidents, I know Gary wanted to talk a little bit about that often out-of-state or multi-state accidents get very confusing, but it seems to me that New York's right of recovery against a non-covered person does apply in accidents outside of New York. So at least as far as New York was concerned, if we've paid New York PIP on a loss that occurs in New Jersey, as far as New York's law is concerned, we'd have a right of recovery if the other vehicle was not a New York vehicle carrying New York PIP. Gary, did you want to say a little bit more about the conflicts of law?
No, you know what? I'm going to actually get to that toward one of the last slides.
Okay,
so we're good. You can keep going. By the way, I apologize that the slide on the PowerPoint, look, we added something yesterday in where it says statute of limitations there. It should read statute of limitations dash 3 years from each payment, and Noah will talk about that now.
Okay. Subrogation against covered person. Subrogation is here an inartful term. It's really what's called loss transfer and is a statutory right. It's in the statute, and it's not subrogation, and that has some certain effects here. Okay. So if we have a tortfeasor who is a covered person, basically meaning they have New York PIP, then we still may have a right of recovery for our PIP. However, only if a vehicle involved in the accident weighs over 6,500 pounds unloaded, or is a vehicle carrying persons or goods for hire. So basically your livery vehicle, a delivery truck, things like that. If any vehicle involved in the accident is one of those vehicles, then we're going to have a right of recovery. It doesn't have to be the at-fault vehicle. So let's say we have a 50-car pileup, and the last car, the front car in the 50-car pileup, who is stopped and didn't do anything and gets a little scratch on its fender, happens to be a taxi cab. That triggers the right of recovery, and now we can go against the at-fault party for recovery. Okay? The recovery is by arbitration. New York law requires arbitration of these matters through arbitration forums. It is essentially a direct claim against the insurer of the at-fault party. Again, not really a subrogation claim. Comparative fault laws can apply, so there can be arguments as to who is at fault and for how much. But worth noting at this point that New York is a pure comparative negligence state. So that means whatever we're recovering in subrogation, if our insured is 90% at fault and the tortfeasor is 10% at fault, we can subrogate for that 10%. So that's an important thing to know and a good point to mention at this point.
Watch out for the counterclaim.
That's exactly right, but you know, that counterclaim is probably coming anyway. So, but certainly it's worth noting. And sometimes, for instance, let's say you have a truck involved that has cosmetic injury damages. You know, our damages could be much bigger. So finally, statute of limitations, very interesting. Since it's a statutory right of recovery, the New York courts have interpreted that the right of recovery attaches with each individual payment of PIP. So it's not by the date of loss. Whenever we go to arbitration forums, we are within statute for anything that we paid within 3 years. And so sometimes file that's been collecting dust may not be as statuted out as you might fear when you find it hiding under your desk or something like that. So 3 years from each payment for the statute of limitations. You also have a right of recovery for priority of payment. This comes up when one insurer pays PIP and really another insurer should cover. And this also goes through arbitration and arbitration forums, also 3-year statute from each payment. And two important notes is that in New York, the PIP follows the vehicle. So you go to the vehicle involved in the accident. That if the person is struck by as a pedestrian, they get their PIP from the vehicle that struck them. If they're a passenger in the vehicle, they get, or a driver of the vehicle, they get the PIP from that vehicle, as opposed to some other systems, for instance, New Jersey, where you go to your own insurance coverage. Also worth noting that in New York, workers' compensation coverage is primary over PIP. So if you paid PIP and your insured turns out to be in the course of business and eligible for workers' compensation benefits, we may have a priority of payments claim against the comp carrier to get our PIP back. Moving along, on the next slide we have optional basic economic loss, OBEL. As we mentioned, OBEL is the same as PIP and treated the same. So all the rules are the same, and if it's a non-covered person, you have a lien for the first 2 years, and if suit is not filed within the 2 years, then we can file direct suit for recovery of OBEL as well. Additional PIP benefits is always recoverable in New York because it's not part of the basic economic loss that gets into the no-fault system. It is always recoverable. It is a 3-year statute of limitations from the date of loss. That's because this is really a more plain vanilla subrogation claim, and the first rule of subrogation is that your rights are the same as your insured's rights. And your insured only has 3 years to make a claim for damages for bodily injury. Similarly, we only have 3 years to file an additional PIP subrogation claim. We talked a little bit about intervention and stating liens versus filing your own lawsuit. Obviously, filing your own lawsuit, sometimes it's more costly, but it's often a better way to make sure that your rights are going to be preserved and respected within all the litigation that's going on, and that's probably going to be the gold standard of taking care of your claims, but at the same time, maybe a more costly and bothersome approach. There's also a final area for recovery of PIP in New York is from an intoxicated driver. 5103B basically says that emergency services have to be recovered. Even though you can deny PIP coverage to someone who is intoxicated, you have to cover emergency services, but you can then recover any of those payments from the intoxicated person. Okay, moving on to page 13, and I think Gary is going to take over from here.
Yeah, one of the things, let's start with this. What we've just talked about is like cold fusion. This is extremely complicated stuff. And as I mentioned earlier, it's a moving target. And it's exacerbated exponentially by the fact that you have cars traveling from New York into New Jersey or Pennsylvania or Connecticut or all 50 states. And so you're going to have this menagerie of different laws. So many of us could take this, attend this webinar in the morning and handle our subrogation claims in the afternoon and need to go back and have the webinar represented the next morning. It is that complicated. What we try and do, in fact, we've sort of tried to set out in easy to understand terms all of the subrogation, not only for New York, but all 50 states in our book, Automobile Insurance Subrogation in All 50 States. Many of you have it, many of you don't, and for those of you who don't, we're going to have an opportunity here for a trivia question, and the winner of the trivia question will receive a complimentary copy of that book. I don't know, Jamie might know, I don't know what it's selling for now, but it is the most expensive of our books, and that's not we don't set the price, the publisher in New York does. Hey, our publisher is in New York. No, it's their fault.
Hey, excellent. Well, I have to say, Gary, I definitely think that book is, and well, all of the 50 state books are quite worth the price of admission. They really cover a lot of information and are a quick reference for a lot of the case law and statutes. And, you know, this is very complicated information, and each state has its little intricacies. What I like to tell people is that the key, and this is a general rule of lawyering, you don't have to know the right answer offhand. You have to know the questions offhand. You have to be able to look at something and at least be led to scratch your head and say, you know what, can I recover this? Or what do I need to do? As long as we recognize the issues, we can always go to Gary's book and we can find out what we need to know. It's when we look at a file and say, this isn't recoverable, and we put it away, and then we've forgotten it, and we lose an opportunity of recovery, or maybe someone comes and gives a second look and takes most of the money we might have recovered. So that's really, I think, to me, the key for a lawyer or for a subrogation professional, to be able to spot the questions and have resources for where to find the answers.
All right, and now for the fun stuff. We're in New York, so let's talk about something that happened in New York back in August of 1969, Woodstock. Woodstock took place at a dairy farm located in Bethel, New York, August of 1969. Which of the following songs was not played at Woodstock? Proud Mary by Creedence Clearwater Revival, Free Ride by the Edgar Winter Group, or Going Up the Country by Canned Heat? I'll repeat the question, and the first person to email Jamie with the answer, her email, many of you have it, but it's jbreen, J-B-R-E-E-N, at mwl-law.com. Which of the following songs was not played at Woodstock? Proud Mary by CCR, Free Ride by Edgar Winter Group, and Going Up the Country by Canned Heat, but this is a record. We already have an answer. And the winner is Karen Kelly. Karen, that's awesome. I actually ran this question by my partners, and only one of my partners got it right, and he was actually older than I was. So, but I'm sure you're not old. But congratulations, Karen. Jamie's going to get a copy of our book out to you. And I'm going to have another trivia question in a minute, just because you guys had to be inconvenienced with yesterday's debacle. But let's get back to subrogation, collision subrogation in New York. One of the sort of misconceptions and urban legends, if you will, is that no-fault states are hard to subrogate in. Well, they are, except for collision. Many of the most difficult and confusing states for no-fault, New Jersey, New York, Michigan, all get a little bit simpler when you talk about subrogating property damage. And although New York is a no-fault state, the subrogation of automobile property damage is allowed. Collision subrogation is allowed. And we are subrogated to the rights of the owner of the vehicle. The owner, of course, is entitled to the reasonable cost of repairing the physical damage to his vehicle. And here's a caveat. I'll give some kudos to New York, together with the difference in its market value before the accident and after it's repaired. So New York does allow an injured party to recover diminished value. They've long been recognized in this regard that the purpose of a property damage award is to make the owner whole in each case. So in a case involving the rear ending of a Mercedes-Benz with only 398 miles on it, the insured sued the tortfeasor after he was paid for the cost to repair the vehicle, and the court held that the measure of damages for the injury to the automobile resulting from the negligence is the difference in the market value immediately before and immediately after the accident, or the reasonable cost of repairs necessary to restore the car to its former condition, whichever is less. But it disallows the recovery of loss of resale value by saying, and the court wrote, in New York, the owner of personal property can recover not only the cost to repair the damaged property, but also its after-repair depreciation in value. So one of the examples I like to give is there's a case involving a rather expensive automobile, and right after it was purchased, there was an accident, and the owner was allowed to recover not only the difference in market value, but also the loss or the reasonable repair cost rather, but also the loss in market value or the diminished value of the car. And it's important to remember too that a lot of the landmines that trial lawyers and trial lawyer-leaning judges throw in our way in New York, such as the anti-subrogation statute 5-335, that Noah has gone over in some detail, is not applicable to property damage. So collision subrogation remains fairly viable in New York despite all of the confusion and all of the problems. And again, kudos to New York when we get to the made whole doctrine, which is one of the nemesis of subrogation in most of the other states. We all know the doctrine, you can't subrogate unless the insured is made whole. But in New York, made whole is not as strong of a doctrine as it is in most other states. New York is a little bit late to the party when it comes to made whole, and it's not run into as often as it is in other states. And you might ask why. Well, because there's plenty of trial lawyers in New York, and the answer, at least in my opinion, is that trial lawyers have already put the stranglehold and created enough of a maze for subrogation that the made-whole doctrine isn't really their main source of combating subrogation in New York. It's all of the things that Noah's been talking about. Now, that's just my opinion, but it may explain why, although New York has applied the made-whole doctrine, it mainly does so in cases such as shareholder derivative suits and cases along those lines. When there are multiple plaintiffs, each insurer needs only to establish that its individual insured has been made whole before subrogation is allowed. Now, that's just generally. But the made-whole doctrine isn't going to create an obstacle to subrogation as it would in many other states. So that's good news. The same is true with the common fund doctrine. Okay, the common fund doctrine, where trial lawyers can't defeat your right of subrogation, they at least try to whittle it away by claiming a fee out of your subrogated interest or your lien, claiming that they've done a lot of work in the case and therefore should be paid for that work. But the common fund doctrine in New York, again, is applied mainly in suits against persons involved in the cases I could find are suits against the city by persons involved in a redevelopment project, shareholder derivative suits, suits by ratepayers against utilities. So although New York recognizes the common fund doctrine and actually refers to it as the substantial benefit rule, it hasn't been applied in cases involving health insurers, and it has been addressed and rejected in auto subrogation. So that's good news. It's limited to those exceptional cases in which dominating reasons of justice require attorney's fees for an award, and a lot of the decisions sort of make it an afterthought when it comes to subrogation. So that's sort of good news for us when it comes to some of the anti-subrogation efforts by trial lawyers and judges. Now, another complicated area that we run into is statutes of limitations. Noah, do you want to talk a little bit about the limitations?
Sure. Okay, so statute of limitations, of course, this is always going to be an important question. Sometimes, we want to make sure that we're within the statute at all times, but I think it's always good practice to make this the outside limits, but you're often going to be better off suing well within the statute of limitations for a number of reasons. First of all, easier to make sure you're going to be able to serve a defendant, easier to make sure if there's some problem, you can correct the problem. If you sue right on the day of the statute of limitations and find out you named the wrong party or you're in the wrong state or whatever, it's much harder to fix things. So always best practice, get things to your attorney earlier than the day of the statute of limitations. I'm sure both counsel will appreciate that as well. Okay, so claims for personal injury and property damage in New York have a 3-year statute of limitations, and hence any subrogation we do for such things has the same limitation. Claims for breach of contract are 6 years, and then you see mention of basically a claim for first-party benefits. You're going, someone complaining to their UM, SUM carrier that they haven't been covered properly. That's going to be a 6-year because that's essentially a contract claim right there. Worth noting, of course, there can be issues. The insured still would have to take out their bodily injury claim against the tortfeasor within 3 years of the statute of limitations, 3 years of the date of loss. And if they didn't do that, that might prejudice our subrogation rights and might be a basis for denial of coverage. So something to think about when that comes up. PIP subrogation has some very interesting situations. We mentioned loss transfer claims are 3 years from each payment. Additional PIP, since it's an actual subrogation claim, is 3 years from the date of accident. Claim against a non-covered person. I think we need to clarify this a little bit. If we're seeking PIP recovery from a non-covered person, we mentioned for the first 2 years, you have if the bodily injury suit is filed within 2 years, you have a right of recovery as a lien against that claim. After 2 years, then if the bodily injury claim was not filed, then we can sue directly. And actually, the statute of limitations runs 3 years from the 2 years after the accident, because essentially our right of suit didn't attach until 2 years after the accident. So the statute of limitations will actually run until 5 years after the accident. That's kind of a very unusual statute of limitations that New York has for that situation. We wanted to mention, and we're not going to get too far into it, but with all of these statute of limitations, beware of tort claims. If we have a state or municipal agency involved in the claim, that may well shorten up the claim to the statute of limitations. Might require a tort claims notice within a certain amount of time, and also suit within a certain amount of time. So that's things we want to be careful about. Okay. Going further into some of the anti-subrogation, well, actually, first we're going to cover releases. This comes up every once in a while, and New York is somewhat helpful in some of the rules it has. We've all had these situations where we seek subrogation and the defense carrier starts waiving a release that was signed by our insured. Did that release prejudice our right of recovery? And the answer is that yes, it may. Our subrogation would be barred if there's a valid applicable release from our insured. However, if the third-party carrier had notice of our claim and basically in bad faith went and got a release from our insured, we may be able to bust through that release. Of course, that means, as we all know, send subrogation notices early and often. Make sure people know about your claims. Additional PIP subrogation, since that is a subrogation claim, that claim may be prejudiced by a release from our insured. That's different than a PIP loss transfer claim, because a PIP loss transfer claim, as we mentioned, is not subrogation. It's a direct claim from the insurer against the other insurer in the situation where there's the 6,500-pound vehicle or the vehicle for hire. So since that's a direct right of recovery, a release is not going to affect our claim. Going back to the first bullet point, I didn't mention the release, in order to affect our right of recovery, has to be executed before we've paid out our benefits. Once any benefits are paid out, the subrogation right has attached to the insurance company, and the insured no longer has the power to release that claim. So if we paid our property damage claim a month after the accident, and then 6 months later our insured got a settlement and signed a release, that's not going to affect our claim. Finally,
jump in.
Yeah.
Oh, I'm
Yeah.
sorry. No, let me just jump in. We are getting some questions already, and this one is relevant. Connie from Newark, so right across the river, has a question here that kind of relates to something you just indicated about tort claims. She says, what if a government entity is involved but I fail to give notice? And I thought I'd just add that there's a couple of circumstances where an auto carrier can still recover from a municipality without submitting the tort claims notice. The most interesting and the one you should remember is that where recovering PIP in an accident involves a vehicle for hire or weighing over 6,500 pounds, i.e. lost transfer, and the municipality is a covered person, this becomes a statutory claim against an insurance company or a self-insuring municipality. It doesn't matter which. It's not a tort claim. So you wouldn't be able to be required to file the tort claims notice. Another exception where you haven't filed your notice is where the insured has filed the notice. There's a case called Hartford Insurance Company versus City of New York that I know of that's fairly recent that says that'll suffice. And then thirdly, of course, there may be some exceptions for actual notice. So I thought I'd get that question out of the way. Go ahead, Noah.
But finally, also worth mentioning along those lines, there are some provisions where one can apply to a court for leave to file a late notice. And so these are certainly complex issues and worth reviewing with a competent attorney the particular situation and see if it can be saved. One final point on the previous slide, as far as releases are concerned, while we mentioned some times where a release won't affect our claim, one has to also be careful that sometimes our insureds will sign a release that indemnifies the tortfeasor from any claims arising out of the accident. And that could potentially mean that even if we still have a subrogation right, that we go after the tortfeasor and the tortfeasor bounces back and says, your insured agreed to indemnify me. So you have to be careful for that. I think sometimes those agreements are a little bit not above board and might be somewhat questionable. But I have seen those asserted, and it's worth, even with the lost transfer type situation where clearly a release shouldn't affect our rights, to the extent we're in contact with our insured and their attorney to, let them know about what claims we have out there so they know not to indemnify the tortfeasor from those claims. Again, send notices early and often, I guess, to anyone who is willing to listen, or potentially even if they're not willing to listen. Okay, on this slide, just worth noting that there is particular regulation in New York that allows us to collect, in our subrogation claim, to collect the deductible on behalf of our insured, and in so doing to basically prorate whatever recovery we make. So as a quick example, let's say our insured had a $5,000 deductible, there was a loss of $10,000, and we recover $5,000. So we've basically recovered half of the claim, and so we'll reimburse our insured for half of their deductible. They'll get $250.
I might also mention that our website has a chart, it has many charts covering all aspects of subrogation, but one of the charts that's most used is the reimbursement of deductibles chart, which covers this topic for all 50 states. And in states where there is no regulation, such as this reg in New York, we've actually called the insurance commissioner for the state and asked them for their best recommended practice. And 99% of the time they were clueless, but I did get to somebody who at least had an idea of what they would recommend, and then at least we have something that we can lay claim to if one day one of our companies is the victim of a class action suit for failing to reimburse deductibles. We can say, look, our lawyer did call the insurance commissioner. We asked, this is what they said, and this is what we've been doing. So it's hard to claim that that's bad faith. I know we're running a little short on time. I anticipated we'd be about 15 minutes long, and hopefully we can stick to that. But Noah, next slide.
Okay. Next slide, we're getting back into the collateral source rule and some anti-subrogation rules. CPLR 4545. This applies to trials only, and it says unless there's a statute saying so, we cannot, in the bodily injury trial essentially, introduce any losses for anything that was paid by insurance, and that's, again, meaning that we're going to have to sue separately, and again, there's the anti-subrogation law that may extinguish our right of recovery if our insured settles the insured's claim. And that's the 5335 that we discussed. Worth mentioning that there is an assembly bill that's been passed through both houses of the legislature, awaits the governor's signature, that would adjust the anti-subrogation law a little bit. The reason for that is that the anti-subrogation law was primarily meant to avoid ERISA subrogation of ERISA claims, particularly when it's what's called a fully insured ERISA claim. And Wirtz versus Rawlings basically found that for a number of reasons that ERISA claims still survived the New York anti-subrogation law, and so there's a pending adjustment to the law that most significantly, the law currently says that if your insured settles, you can't subrogate unless there is a statutory right of recovery. They're removing the language unless there's a statutory right of recovery. So basically, I mean, well, that's not quite the best way to explain it, because statutory rights of recovery that do exist will still be covered, but they're basically have to have particular carve-outs, because basically Rawlings said, well, ERISA is a federal statute. So they're removing that unless there's a statutory right of recovery, and basically referring to particular statutes that allow recovery. Again, Gary mentioned it doesn't apply to property damage. The anti-subrogation law really refers to medical bills and certain other economic losses for bodily injury.
You know, the Assembly Bill 7828, I attended a seminar a few weeks ago in which the presenter got it wrong. He indicated Assembly Bill 7828 was in the Assembly, and another speaker said it was passed by the Senate. It's been passed by both houses of the New York legislature, and it has been sent to the governor's desk for signature. I talked not only with the governor's liaison officer, but also with his chief of staff, with their chief of staff over there. And what they told me is that 7828 is sitting on the desk. I think NASP even sent out an amicus alert about this recently. It has been received, but it has not been signed. And I think we can claim some credit here. I sent a letter to the governor. Noah, I think, did. Several other members of NASP sent letters explaining why it's probably not good for New York. The whole purpose of the Assembly bill was to mute and neuter the ERISA results, the anti-preemption or the preemption results of Wirtz versus Rawlings. But of course, wouldn't you know it, trial lawyers take every opportunity they can to stick in other anti-subrogation measures into the bill, and as Noah said, most of those have been removed. But so the bill has been passed, but it has not yet been signed by the governor, and we will certainly let you know when it has been passed.
Okay. Effects of the 7828, if it gets signed by the governor. Effect on PIP subrogation is none, because they did put a carve-out in for PIP subrogation, and of course loss transfer isn't subrogation, so that wouldn't have been affected in the first place. Effect on APIP subrogation, none, because there's a particular carve-out for that. Effect on workers' compensation subrogation, none, because there's the carve-out for that. Effect on short-term disability benefit subrogation, possibly extinguished because there is no carve-out for that. And there's a good chance that's because someone just simply forgot about it. But unfortunately, New York courts are often going to say, well, they didn't carve it out. If they want to correct that, the legislature can correct that, but for the moment the statute says no. So we imagine if the law is signed into law as written, that short-term disability benefit subrogation will be a thing of the past in New York.
All right, let me talk a little bit about some of the other issues that affect automobile subrogation in New York. But before I do that, I want to give our second trivia question. We're going to give away another book thank everybody for sticking with us through the issues, the technical glitches that we had yesterday. Also, I got an email here. John in New Haven wrote, I thought Edgar Winter did play at Woodstock. Well, you're right, John. Johnny Winter, Edgar's brother, did perform at Woodstock on Monday, August 18th, and Edgar Winter was featured on 3 songs he performed. I think it was at midnight on that night. However, the Edgar Winter group wasn't formed until 1972, and Free Ride wasn't recorded until 1973. So our previous trivia winner gets to hold on to her book. Also, the next trivia question, and this is breaking news in the subrogation world. On May 7th of 2013, Oklahoma Governor Mary Fallin signed into law SB 1062, which transformed the workers' compensation system in New York completely. It transformed it from a court-based judicial system of workers' compensation, where all matters involving workers' comp have to go through the circuit courts, the state trial courts. It transformed it to an administrative system, which most other states are, and which instead makes use of administrative law judges who are not part of the civil court system. So the trivia question is, what is the only remaining state which employs a judicial or court process for the resolution of workers' compensation claims? In other words, you don't go to an administrative law judge, you don't go to an administrative hearing, you basically take care of everything in the courts. And those of us who've been practicing law for a while remember back to when most states were like that. But so that's the question. Which state is the only remaining state employing a judicial court process for the resolution of workers' compensation claims? Now, sudden emergency doctrine, often confused with unavoidable accident. When related to the sudden emergency doctrine is when the defendant is faced with a sudden and unexpected emergency which leaves no time for he or she to reflect or give thought or deliberation or consideration, and it causes the defendant to be so disturbed that the defendant must make a speedy decision without weighing the alternative courses of conduct. All right? Sudden and unexpected emergency is the key here. The defendant is not negligent if the actions he or she takes are reasonable and prudent in the emergency context. But the defendant must not have created or done anything to contribute to that emergency. An example could be a child running out between cars into a parked into the roadway. And I had a case like that down in Fort Worth just recently, which was tragic, but that's exactly what happened, and the defense in that case is sudden emergency. Related to sudden emergency is the defense of unavoidable accident, which New York doesn't follow, but a jury may be instructed. I take that back. The jury can be instructed under the right circumstances as to unavoidable accident, but only if they could find that the accident resulted from an unknown cause or in an unexplained manner that wasn't occasioned by the negligence of either party. So those are the two defenses. Seatbelt. The seatbelt law in New York. New York has a seatbelt law which requires all backseat passengers to be restrained by a seatbelt or child restraint systems. Front seat passengers and the operator have to wear a seatbelt or a child safety seat. So New York does, as a result, have a seatbelt defense. And in 1974, the Court of Appeals held that the seatbelt defense can be submitted to the jury only if the defendant can demonstrate by competent evidence a causal connection between the plaintiff's non-use of a seatbelt, an available seat and working seatbelt, and the injuries and damages sustained. But the seatbelt defense goes only to the mitigation of damages, not the comparative fault. So if plaintiff isn't wearing his or her seatbelt and is involved in an accident, the defendant can say, hey, he or she didn't wear her seatbelt, but that only goes to mitigation of damages, and then you get into second collision within the vehicle and issues like that. The jury cannot put 20% negligence on the plaintiff for not wearing the seatbelt because the plaintiff didn't cause the accident as a result of not wearing the seatbelt. Bailment. This is a case that, or a rule of law, or actually a rule of evidence too, which comes up in New York, where you have a vehicle that's turned over to a repair shop, or some personal property is delivered to another person, and it's basically a contract, express or implied, that provides after somebody turns over property, there's an implied contract that they're going to get it back. Taking a vehicle into the shop for repairs is a good example. Even borrowing a vehicle or lending your vehicle to somebody is an example of a bailment. And there's a prima facie case is made if you prove that the property was given, if you prove that your insured's vehicle was left at Dick's repair shop to have the brakes fixed, and that the property wasn't given back, then the burden shifts. You no longer have to prove that Jack's repair shop was negligent. You just have to prove that the property was given, and now Jack and his attorneys have the burden of going forward with evidence to prove that they use reasonable care in taking care of the vehicle. Once they prove reasonable care, an example could be you leave the car out in front of Jack's repair shop and give him the keys, and he said, yeah, I'll take care of it. I'll have your brakes ready by Tuesday. And the next thing the insured knows, he or she gets a call from Jack saying, hey, your car was stolen. We've reported it, and we can't give it back to you. They have the burden of proving reasonable care. And what's nice about bailment is it has a 6-year statute of limitation that goes with it because it's based on contract. Guest statutes, another issue. Many states had guest statutes throughout the early 70s, but into the mid and late 70s, guest statutes which were simply statutes which didn't allow guests in a vehicle to sue the driver or family members to sue another driver. Those statutes were passed to prevent collusion because, believe it or not, there's collusion, and sometimes there's actual fraud, if you can believe that, where the operator would be sued by the passenger for an injury, and the whole thing could be a setup. So, but these guest statutes really phased out, and I don't know that there's any states that still have them. The family purpose doctrine is a doctrine which states that if the head of the household, the owner of the vehicle, gives the vehicle to a family member for a family purpose, then the owner is liable automatically without proving negligent entrustment, without proving anything else. They're just automatically liable. New York has no guest statute, and it has no family purpose doctrine, but guess what? It doesn't need one. New York, and I give them kudos here as well, has Section 388, which basically says that every owner of a vehicle used or operated in the state, every owner of a vehicle is liable and responsible for death or injuries to person or property resulting from negligence in the use or operation of the vehicle. So the proof of ownership of a motor vehicle creates here, again, a rebuttable presumption that the driver was using the vehicle with the owner's permission, because, of course, they'll always say, oh, he just took it. I didn't give him permission. But there's a presumption that permissive use is involved, and this presumption may be rebutted. But this puts automatic liability on the owner and is a tremendous asset to us when we're subrogating. Of course, not to get too into it, but the Graves Amendment precludes vicarious liability of commercial automobile lessors and rental car companies, if you're familiar with the Graves case. But that's a significant advantage to us when subrogating. A couple other issues that we want to talk about. Multiple claims in excess of liability limits. Again, here, every state is different, but in New York, an insurer faced with multiple claimants and not enough third-party limits may follow the first-come, first-serve rule. They may settle with some of the parties injured in the auto collision and is thereafter liable only for the remainder of policy limits, even though it may have been aware of other claims that probably would exceed policy limits. Some states are not like that. Some states you have to interplead the money. Some states you have to use good faith and do pro rata, and there's all kinds of different formulas for it, but there is no authority for the court to ratably distribute policy limits among the various claimants. So if you're subrogating, you can provide case law. In this case, there's a case called Gertis versus Travelers Insurance Company back in 1981, which basically says first come, first serve. Dram shop liability. Dram shop is an old English term for a bar. As many of you know, that under this law, the Dram Shop Act in New York, it's illegal for businesses to serve alcohol to persons who are visibly intoxicated. That's the key. The definition of visibly intoxicated is largely left to the discretion of the employee who's pouring the drinks, the bartender. Visible intoxication may be indicated by such things as slurred speech, bloodshot eyes, lack of physical coordination, so you can see that there is going to be some litigation involving these things. New York is fairly astute in that they do not allow patrons themselves, the consumers of the alcohol, to sue the bar. Instead, the bar or tavern may be held liable for damages caused to third parties who are injured by the consumer of the alcohol. An example would be if a bar serves a person alcohol, then that person drives away and injures another person in a car accident. Those other people who are injured can sue the bar. And that's true also for pedestrians. But damages are not limited to vehicular accidents. And this is interesting because we just saw, what was that, the Red Sox game? No, it was a Patriots game, Redskins-Patriots, where there was a fight after the incident, and the gentleman was probably intoxicated. So in New York, employees are also prohibited from or aren't allowed to serve somebody who's visibly intoxicated, and if they go out and get in a fight or cause property damage, the dram shop can be responsible. So in order to prevail in a dram shop action, the plaintiff has to prove three things: the person who injured them was intoxicated, that the bar sold or provided the drinks or the liquor to the intoxicated person, and that the bar owner or the bartender knew or could tell that that person was visibly intoxicated, and plus the defendant must have caused or contributed to the person's subsequent intoxication. So the drinking establishment will be liable both for the direct actions of the patrons as well as any instances where the patrons is simply a party to an incident. Offers of settlement and judgment, I like these things. Our book goes through in all 50 states what statutes are available to us, because if you have a $2,300 property damage, a lot of times all you get is a yawn and you hear crickets when you send your demand letter to the third-party carrier, because there's really no risk there. I mean, what do they have to lose other than, you know, ultimately paying $2,200? So why should they pay you? Well, the answer to that is that sometimes states have an offer of judgment statute or an offer of settlement statute, which would allow the recovery of costs and or attorney's fees in the event the plaintiff recovers more than an offer of judgment made before suit was filed. So New York law does provide for prompt payment of settlements, and under Section 5003A, the defendant has 21 days to mail the settlement check from the date it receives settlement documents. So that's sort of you know, another plus. With regard to suspension of driver's licenses, the license of an uninsured at-fault driver may be suspended administratively by the department after hearing and conviction, but an insured party cannot request suspension. So the insurance company must notify the DMV when it gives a policy of insurance. There's a requirement that it notify the DMV every time insurance is obtained. And if there's the police officer pulls someone over, or there's an accident and someone doesn't have insurance, they notify the DMV, and then the DMV automatically, administratively, will suspend the driver's license. Not less than 10 days nor more than 60 days after the commissioner receives notice of an accident resulting in injury or death or property damage in excess of $1,000. Also, if there's a judgment, and this is often where we are asked to get judgments on behalf of clients, the clerk or judge, upon written request of the creditor, that's us, after 15 days following entry of a judgment, will forward to the commissioner of the DMV a certified copy of any unsatisfied judgment, along with a copy of the complainant summons and a copy of any police report. And then it's done on a form SR-60, and that's mailed to Albany, and then that suspension remains in effect until the judgment is stayed, satisfied, or discharged. New York has a little caveat, though. Any judgment is deemed satisfied when $25,000 has been credited. So they sort of cap it. They don't want people to be without their licenses forever. So if they pay $25,000, they get their license back where there's injury or damage to one person. And $50,000 is the cap where 2 or more persons are involved. And $10,000 is the cap where there's damage to property of others, where that's involved. We do have a winner of the second trivia contest, Jody Scanlon. Congratulations. That's pretty good. Tennessee is the only state left that follows the court-based judicial system, and I understand they're even talking about changing that, so that may be extinct soon. We are out of time. I've got a few questions here we'll try and get in, and because we're over, I'll grab just a few. And the questions that we cannot get to, and I have them all, or they're coming in as I speak, we will answer those today or tomorrow. Both Noah and I will roll up our sleeves and get answers to you. Noah, here's a question. Robert in Lansing writes, can you explain the interaction between PIP and workers' comp and where this might lead to potential recoveries for the auto or comp carrier? It's a good question.
Excellent question. Lots of ins and outs to that, but just a couple of things to discuss as we paint with a little bit of broad strokes. First of all, we mentioned that workers' compensation is primary over PIP. So if PIP has been paid out and it turns out the injured party was injured in the course of business, the PIP carrier can go to the loss transfer arbitration to recover those payments under priority of payments. For those of you out there who are working on the workers' compensation subrogation side, it's also worth noting that a lot of the rules that we discussed about recovery will also apply to workers' compensation benefits as well. And the short version of that is that if a comp carrier pays a claim that otherwise PIP would have paid, it's what's called comp in lieu of PIP, and it has the same recovery rights as a PIP carrier. So if comp in lieu of PIP was paid and you have a 6,500-pound vehicle involved or a vehicle for hire involved, you're going to be able to go to arbitration at arbitration forums to recover that, just as one example. But basically, it's as if the comp carrier paid PIP. But it's worth noting that comp coverage is not always congruent with PIP. For instance, I believe comp pays a little bit more for lost wages than PIP. So it's not as simple as just saying, oh, the first $50,000 that I paid for PIP in a motor vehicle accident is comp in lieu of PIP. There may be some money paid out very early and within the first $50,000 of comp benefits that may not be in lieu of PIP, and therefore those would go under the compensation subrogation statute, which generally is more permissive but has certain requirements like notice requirements and the like. So basically, comp steps into the shoes of PIP for a lot of that which PIP, for anything that PIP would have paid, and that's treated pretty much the same as PIP.
This is kind of cool. Elizabeth in London. Elizabeth, you're working late. I'm looking at my watch, and I know what time it is there. Has a question. What if New York insured travels to another state and is involved in an accident there? This smacks on some of the things that Noah was talking about involving out-of-state insureds driving here or us driving to another state. And it really opens the Pandora's box of conflict of laws, which is the set of laws that recognizes that one state must give recognition or comity, C-O-M-I-T-Y, to the laws of another state. The legal, what happens is if a New York insured drives to Wisconsin and is involved in an accident here, and a lawsuit here results, and the courts are now dealing with plaintiff versus defendant, plaintiff being from New York, defendant from being Wisconsin, in a Wisconsin court. Wisconsin law, Wisconsin conflict of law rules will determine which state's laws apply to that lawsuit. And in particular, of concern to us is, of course, which state's subrogation laws. We may like Wisconsin subrogation law, when it comes to subrogating bodily injuries as opposed to New York's laws, because they are kind of screwy. So, but Wisconsin law will determine what happens there. In New York, New York follows the restatement second of conflict of laws in determining the choice of law issues, and under this approach, the law of the jurisdiction with the greatest interest in the litigation is applied. So, no, there is no red line pat answer I can give you on what happens and which law applies, but you must look to all of the factors. Where is the insured? Where is the car stored? Where was the insurance contract entered into? Where did the accident happen? Where is the defendant from? Some cases there's 2 or 3 states involved, and so what the court does is they throw all of these into the hopper and they weigh them and determine which state has the most significant interest in the outcome. And the answer is never consistent, and is always sort of an equitable measuring of rights and remedies. So, but conflict of laws is a subject that will be covered in a separate webinar somewhere after the conclusion of our 10-state series on auto subrogation.
If I may jump in for a moment, yeah. Gary, you had mentioned the guest passenger statute. One of the seminal cases in New York involved that, and it used to be, for the most part, people followed wherever the accident happened, that's what law applied. But there was a case, I think, going back to the 60s from New York, in which a New York chartered bus was in an accident in Ontario, Canada. And Ontario, Canada had a guest passenger statute, and so the driver of the bus, who was at fault, claimed that he couldn't be sued, but the I believe it was New York Court of Appeals said, no, you were driving a bus from New York with a whole bunch of New York passengers with a charter that was chartered for people in New York. Just because it happened to be that the accident happened in Ontario doesn't mean Ontario law should apply, and New York applied New York's law. So that's an example where it's just not as simple as the place of the law applies, the place of the accident applies.
Okay, let's do one more question here real quick. There's a number of questions. We'll get to all of them via email. Army in St. Peters, Missouri, has several questions. I'll do one of them here. I was asked to check with counsel to see if a roller for street highway construction, so like a steamroller, would qualify as a commercial vehicle. It may not be considered a licensed vehicle for the road, thus not qualifying, but it is definitely over 6,500 pounds. I know that, no, I'll let you answer this. I know we have to answer the question as to whether or not the tortfeasor is a covered person, and that sort of dictates where we go from there.
Right, and I don't know, I think we were hung up on the question of does this roller require a PIP under New York law? And that's ultimately the question. In order to be a covered person, you have to be part of the New York PIP scheme. I'm not sure if we ended up finding an insurance answer to that question.
Yeah, I mean, we always have to ask, is the tortfeasor a covered person? In this case, I'm assuming that the roller would be the tortfeasor. If it's not a covered person, then PIP is recoverable by lien, assuming the BI suit is filed within 2 years, or suit if it's not filed. But if it is a covered person, then loss transfer arb may apply if there's a qualified motor vehicle involved. And I did cheat because I got this a few minutes ago. I looked up Section 125, which defines motor vehicles. Every motor vehicle operated or driven upon a public highway which is propelled by any power other than muscular power is a motor vehicle. Then it excludes farm-type tractors, all-terrain vehicles used for agricultural purposes, other than hire farm equipment, including self-propelled machines, and self-propelled caterpillar or crawler-type equipment while being operated on the contract site. So it excludes certain things, but it includes, actually I don't even know. I'd have to read through that statute. So, Army, we'll take a look at that and get a better answer to you. But the answer, of course, is if they're a covered person, then you know where to go, and Noah's told you what your options are there. So, okay, listen, we apologize again. Noah, did you have something to add?
Yeah, I was gonna. There were a couple of very quick questions that I thought were worthwhile to just rattle off answers. Maybe we'll answer by email a little bit more, but I think it's helpful for everyone. One question was, can an adverse covered person be from another PIP state? The answer is essentially covered persons means you have New York PIP, which could be because you're a New York vehicle or because you write or are part of the signatory status for New York, but it has to be that New York PIP applies to the vehicle to make it a covered person. One question was whether the qualifying vehicle, the 6,500 bound vehicle, etc., has to have contact in the accident. What if it just cuts someone off and then causes an accident? I don't think there is case law that really addresses that, and I know that's been an issue in another number of ARBs, and I think it's probably up to the arbitrator to interpret what involved in an accident means. My personal opinion is that involved means you affected an accident, and I wouldn't require contact, but that's if I'm the panelist or if I'm the guy in the black robes deciding it. Someone asked, is a pedestrian a covered person? The answer is basically yes, as long as the vehicle that struck them has PIP, because the PIP follows the vehicle. You would go; they are a covered person under the PIP of the vehicle that struck them. I think if that vehicle doesn't have PIP, they may be able to go to their own PIP, but I'd have to look at that. But generally speaking, pedestrians are covered persons and go to the vehicle that struck them. Finally, does recovery of OBEL require arbitration? Absolutely. In those cases where PIP requires arbitration, OBEL is part of basic economic loss, and so all of the statutes that require things for recovery of basic economic loss apply to OBEL. So.
All right. Well, that concludes our webinar. Next webinar, actually, the next state that will be covered in this series is going to be Illinois. I understand we don't have a date for that yet, but we'll have that up on the website, and it will go out via our newsletter fairly quickly. So thank you for joining us. Noah, thank you for helping out. It was a tremendous help.
Absolutely, and thanks for inviting me to participate.
All right. Take care.
Very good. Thank you, everyone.
Bye-bye.
The organizer